Thank you, Chairman Jordan, and I now recognize Mr. Min for 5 minutes for the purpose of asking questions.
Thank you, Chair Gill, Ranking Member Simon, for hosting what appears to be a rerun of last week's hearing. Before I get into the substance of this hearing, I did want to just note again something that I think goes to the heart of the credibility of this particular hearing. This task force was created to defend constitutional rights and expose institutional abuses. We have myriad examples of this happening right now, the issues that my constituents are calling me about, whether it's the illegal war in Iran, whether it's the illegal abuses by ICE, real constitutional abuses, and instead of focusing on any of these actual constitutional abuses by President Trump, we were once again focused on DEI, diversity, equity, and inclusion. I also want to just note something just to show how unserious this hearing is. Ms. Benke, I just want to clarify, you're the president of the American Bar Association, the primary professional organization of lawyers in the United States. Is that correct?
That is correct.
Does the ABA accredit law schools?
The Council of Accreditation and Admissions to the Bar does the accreditation work, but that is separate and apart from the association as is required by the Department of Education.
So the Council of the ABA's section of legal education admissions, the Council, is responsible for accreditation, and that, as you noted, is a separate entity as required by the Department of Education. I want to apologize on behalf of this entire committee for wasting your time and inviting you here, because this is not supposed to be you, but someone from the Council that should be addressing our committee. Is that correct?
The Council is responsible for accreditation, so I can't speak on behalf of the Council.
That's fair, and I think this is a failure of this committee, showing how unserious this is, because we don't even understand apparently the basic structure of legal education. We're inviting the wrong witness to testify before this committee. This is not a minor failure. This is something that goes to the heart of this. This is a bunch of mistruths, half-truths, trying to create a smear campaign against the ABA and against law schools. Now, I was a law professor myself once upon a time. I actually served on our admissions committee at one point, and I have some familiarity with what happened here. And I just want to address Mr. Blackman. I had a chance to read your testimony, and I will just note, I don't know what the policies at Penn State Dickinson are, but at my law school, at every law school I'm aware of, it would be extremely inappropriate for a 1L student to write a message to every single person on the law school email list. Probably prohibited at my school. So I'm not sure why you think that's a suppression of your free speech. It really has nothing to do with the content of what you're saying. I would suspect that that is a policy matter of we don't want 1Ls addressing the entire law school community. Another point I would make to you in regards to your testimony, you make a great deal about how you were forced to take a class on race and the Equal Protection Clause. You understand, I know you didn't finish law school. You maybe finished a semester. That is a core part of the 14th Amendment. That is something that is taught in every con law class in every law school in America, right? I don't know why you thought that was so offensive, why that forced you to drop out of law school, but part of the law school pedagogy is addressing topics that we may not agree with. The idea here is to accustom us with understanding the other side's position, an integral part of being a lawyer. I wish you had taken more classes. I taught many conservative students. Some of them were among my best students, precisely because they challenged the orthodoxy of other students. They made other students uncomfortable, but in that process, they also learned to understand and empathize with opposing arguments. And that is a core part of the pedagogy here. Now, I want to just point out another problem here with this entire line of questioning and some of the testimony that we have read today, including from you, Mr. Smith. With one of the relevant cases that has governed basically my entire life on affirmative action, the 1978 Supreme Court decision in Regents UC versus Bakke. As we all know, I think we all know, the Supreme Court in this decision prohibited universities from using strict race-based quotas during the college or other admissions processes. They allowed race and other protected classes to be factors. But when I was on the admissions committee, this was before the decision in Harvard, we were allowed to use race as a factor. We were not allowed to actually have any kind of quotas. We could not say, for example, we don't have enough black students, we need to admit more. That would have been exactly illegal. Ms. Benke, I want to ask you, you're aware of the 2023 Supreme Court decision, Students for Fair Admissions versus Harvard, is that right?
Yes, I am.
And you know that in that decision, they held that UNC's and Harvard's race-conscious admissions practices were unconstitutional under the Equal Protection Clause and Title VI. While I would note that this ended race-based admissions, but did not actually eliminate all DEI practices, and what is still allowed to be quotas or to be factors in admissions. Geographic diversity, something we know universities and law schools take great pride in. We can say we have people from rural Alabama as well as California. We also know that they're allowed to take ideological diversity into consideration. That is something that my law school took very seriously. We hired more conservatives. It was definitely a factor, people that needed a little bump up. We said, we don't have enough conservatives here on our faculty. We don't have enough conservatives in our student body. We admitted those students. We bumped up the faculty for that reason. And I would just note, just to close, that these practices of geographic and ideological diversity actually benefit kids, say, from rural Alabama conservatives much more than they do, say, Asian kids from Irvine. I don't know why we're focused on race and not on ideological geographic diversity. And with that, I yield back.
Gentleman's time. All right.